Hey guys, how's it going? Good morning, good afternoon, good evening. I hope y'all are doing well. Happy New Year's Eve. I hope y'all find a fun way to celebrate, however you choose to celebrate. And if you don't choose to celebrate, I hope you still have fun. Um, so today I'm talking about the 2020 election. And my argument of it is it's not being undemocratic to be like, hey, we need to, this is the first time there was no excuse mass mail in ballots throughout the whole country. The first time. So I don't understand why you're making it so difficult to have a little bit more transparency and verification on all this stuff. You would think it would be like, oh sure, yeah, no problem. Like here it is. We won. But it's like, shh, hush, you're being undemocratic if you even have any fucking questions or if you're even curious about it. And if you see any discrepancies, that's on you. That's your fault. It's like, okay. Um, so I'm hoping to start off this video with a little unity in the sense where there are some things where you need to just kind of drop your party affiliation and just come together on what we have as common ground as Americans. And election integrity is definitely one of them. And war and peace is definitely another one. And an example I have is Robert McNamara. I think I'm pronouncing that right. He was the Secretary of Defense for Johnson, and it is because of him and because he was disillusioned and disheartened with how it was going with the war and it was taking forever. He was like, hey, we need to get all these documents from the very beginning. We need to look through them and we need to figure out what happened and how the best and what the best course of action is to get out of here. He ordered that in 1967, and then May 1968 they started their peace talks, and the Pentagon Papers was just huge. So I'm hoping, and it was very resourceful in like if you're for the troops coming home and all that. Um, and I also want to start this video from a quote from a lawsuit, or I think this one's from the judge's opinion of that lawsuit. Um, anyway, it was Pennsylvania Democratic Party versus the Secretary of State, Bookvar. I hope I'm pronouncing that right. The quote says, all statutes, which are just the election laws, tending to limit the citizen in his exercise of the right of suffrage should be liberally construed in his favor. So in the lawsuit, he was talking about like the date and the signature requirements and just before the process before the ballot and the vote is cast. And in my opinion, it's like, okay, if you want to liberally construe, so the right of suffrage is not just before the ballot is cast. The right of suffrage is also after the ballot is cast, especially when you have like a first time mass mail-in thing. It's like, let's liberally construe it on both sides. Why only liberally construe, oh, we don't need any signature verifications, but we're all going to be super strict and not let you audit and verify, and you're being undemocratic for even having those thoughts. You know what I mean? It seems like let's if you want to liberally construe, let's do it. So yeah. So what basically what in a lot of these lawsuits and a lot of what people are urging their legislature to do is just basically follow the Constitution. Article 2 gives plenary power to the legislature. Plenary, which is just planetary, kind of just, you can get creative with it, I guess. But this, for the sake of free and fair elections, how it usually goes is the legislature passes these election laws, which they follow to administer an election, which results in a popular vote, which they choose the electors based on that. However, these election laws, and I'm going to go all into it, had a lot of modifications to them, and those modifications were not from the legislature. So they're just basically saying, hey, legislature, use your plenary power to select the electors that your constituents actually want. Because that, and they're like, well, you can do that, or we could go the route of, like, so yeah. And also, I want this the theme to this video to be checks and balances, because what I've seen with this election and what I've seen with all this coronavirus regulations and mandates and stuff is the executive branch and the judiciary branch, instead of keeping each other in check, they're kind of using their powers in tandem to limit our rights. And I find that very troubling, and I find that one of the most troubling trends of 2020. Yeah. Okay, so I'm going to go over a little bit of little statistics and data for the mail-in voting for Pennsylvania. For Pennsylvania, over 6.8 million votes were cast in total. Of the votes cast for Trump, he received over 80% of his on election day, and he received 18% of his votes through mail-in ballots or mail ballots. And for the people who voted for Biden, he received 41% of his votes on election day, and he received a whopping 58% of his votes by mail ballot. And again, and so the total mail ballots was over 2.5 million. Trump getting 23% of the votes, and Biden getting 77% of the total mail ballots. And just to note, the rejection rate for this election was less than 0.28%. And the rejection rate in 2018 was around 4.5%. And actually in the Democrat counties was a little higher. So it's a little counterintuitive when to get such a less rejection rate when you would think there would be a learning curve there, especially kind of a glaring one, since it's like a mass mail thing, never been done first time. So this Supreme Court, the lawsuit filed with the United States Supreme Court, it mainly focuses around 3 of the Pennsylvania Supreme Court cases. One happened before the election, 2 after. In these 3 Pennsylvania Supreme Court cases, they decided about the signature verification and analysis that ballots you are not authorized to set ballots aside based on that. And the right to challenge is just based on, you can't challenge based on signature analysis. You can just challenge based on if they're a qualified voter, which I think they consider a qualified voter like if you have the correct name and address. But I could be wrong on that. And then also in another lawsuit, it was like, oh, the term meaningfully observe, meaningfully doesn't mean anything. They decided, the Pennsylvania Supreme Court decided, they say meaningfully observe means you get to be Where's Waldo all the way over there. To me, to have observation means, oh, I can see that these signatures match, I can see that. And meaningful observation is, to me, way more than observing stuff on a ballot, but I digress. And then the other lawsuit, or the third Supreme Court, Pennsylvania Supreme Court case that they talk about for the U.S. Supreme Court lawsuit is just that all about filling out the outer envelope, that, oh, the declaration, like, you don't have to do it, and all the laws, the election laws that that tell you how to fill out that declaration, all those words are ambiguous, so we don't even need it. So yeah, so a lot of these, oh, this is gonna be a long video. Sorry about that if you don't like long videos. So it's a lot of this arguments on these lawsuits revolves around the signature analysis, They also get nitpicky with it, with like the dates and stuff. But what I've noticed, a kind of a trend throughout the lawsuit, at least from the camp of, oh, we don't need signature requirements and stuff like that, is a trend that I've noticed is before this year, a lot of the safeguards in these election laws and stuff, there were safeguards on the voter side and there are safeguards on the election official side. And what I've noticed, a trend this year and in all these lawsuits, is they tend to eliminate the safeguards on the voter side and just have the safeguards on the election official side. And they do that, and then, well, I'll get into it. And so, in my opinion, I think it's very important to have safeguards on both sides, because if you don't have any safeguards on the county election officials or the election officials, then that's obvious. You're like, oh, no, that's not good. But if you don't have safeguards for the voter, that's also just as not good as well. And so that's what to me, what I think I've absorbed is that that's their whole argument for, like, oh, we don't need like all that signature verification. Just is basically taking away all the safeguards on the voter's end and only keeping the safeguards on the county election officials side. So yeah, they talk about the signature analysis was a big thing. Whether you set aside a ballot based on signature analysis was their thing. So yeah, there are 2 times that there's signature analysis. From what I gather, feel free to correct me if I'm wrong. So the first time there's a signature analysis is when a voter applies for a mail ballot. And in that application, you're supposed to sign it, and then the county elections office, they receive it, they see the ballot, they compare the information on the application with their voter registration file or whatever, and they're like, okay, everything lines up, everything looks good, we're going to send you a mail ballot. Because we just don't want to be sending mail ballots willy-nilly now, do we? So yeah. Stay focused. So yeah, and then the second time there's a signature analysis is after the application was sent into the office approved the application, sent the ballot back, the voter filled it out, and then sent the ballot back in an outer envelope. And so that's the second time there's a signature analysis, is when the examination of the outer envelope. And this part's a little confusing to me, because in my opinion, like, I guess the curing process is basically if an election official sees that there's something wrong with your ballot, they set it aside, or they set it aside so they can send it back to you so you can cure whatever was wrong with it, and you send it back. So that's the curing process. And then we have pre-canvassing and canvassing. And by definition, pre-canvassing can start no earlier than 7 a.m. on election day. And canvassing can start no earlier than when polls close on election day. So from all that, the curing process happens after election day. And I think there are some laws, I can't remember if it's Pennsylvania, but there are some states that has laws that are like, they leave like a week or like 8 days or something to accept ballots, especially like for like military overseas and stuff like that. And that's why all these dates are all very important. But anyway, so yeah, I'm just a little confused on that process, but I'm gonna keep moving forward and try not to be confusing to you, to all y'all. Okay, so the signature analysis, there's 2 times there's a signature analysis: when application is received by the office and when the outer envelope is received by the office. So there's two camps here. One camp is the signature analysis and verification is a need and requirement by law, and the other camp is the signature analysis is not a need and not a requirement. So in my opinion, the people who think that there is a need and there is a requirement for the signature analysis is the Carter-Baker report. I think it was published in 2005, but it was about the 2000 elections. And in that report, it basically just said that mail voter fraud is like really prevalent, and we need to be extremely aware of that. And then I also think I'm going to argue that the Pennsylvania law says that there is a signature analysis requirement. I'll get into that. And again, that's just my opinion. That's not the opinion from the judge in the Supreme Court, or the Pennsylvania Supreme Court. And then I also think Act 77, which was Act 77 was passed in the end of 2019, that first allowed this no excuse mail-in ballot. There was a subsection in that act that said that at these satellite offices, they need a voter registration file, right? And so they said, okay, so we'll send you a temporary copy of all these voter registration cards, and you can keep that on your file as your voter registration file. And these registration cards, you have your signature on them. So in my opinion, I think even in Act 77, which allowed for no excuse mail-in ballots, I think even in that act, they have a good faith measure for a signature analysis and all that stuff. And again, I think in the lawsuit, League of Women Voters versus the Secretary of State, that was a friendly lawsuit, in my opinion. And they sued the Secretary of State by saying, hey, there's no curing process in the election laws, and that can disenfranchise voter, or there's it basically, in that lawsuit, it basically acknowledged that there is a signature requirement and that ballots can be set aside based on that signature requirement. However, where the disenfranchisement of the voter happens is the fact that there's no curing process after that ballot is set aside due to signature analysis. That was their complaint in that suit. So I think even they think that there should be a signature analysis. I'm going to talk about that lawsuit later, but focus. Okay. So the arguments for a signature analysis, whether the ballot should be set aside based on that, and whether a signature is even required on the outer ballot. So yeah, one of the arguments that they do in the lawsuit is there's a lot of ambiguity of language. So I guess what happens a lot with law is there's the actual text of the law, and then there's also what somebody interprets from it, which is, I guess, like everyday conversation. But they took it to a next level with this one. So in these lawsuits, they say, or in the Supreme Court, Pennsylvania Supreme Court cases, they say, and the Secretary of State, they say the word shall fill out, that the word shall is ambiguous, and that it's not like you don't have to if you don't want to. And it's like, well, cool. I wish I would have known that, because for all these mask mandates and stuff, all the executive orders and all that, it says shall wear a mask. And it's like, okay, well, I'm glad I don't have to wear a mask in Pennsylvania. Right? Is that, or did I understand that correctly? And then they also say fill out is ambiguous. They say like, oh, you could be like, oh, maybe a voter doesn't know that they have to put the date and address on there when they say fill out. What does that mean? Does it just mean their name? Okay. And then and I mentioned it before, but for like meaningful observation, it's like, okay, if you want to talk about text of the law, the text of the law is meaningful observation. If you want to talk about interpretation of the law, meaningful observation, it seems pretty much, I don't know how you can misinterpret that, but I guess you can. And to them, it just means like you don't have to see shit. And that's meaningful observation, which, from my experience, I can tell you quite a few people who agree that's meaningful observation. Anyway, not talking about that. Oh, okay. And also they say, what is this here? Okay, well, they say, oh, they shall fill out the declaration and compare that information thereon with that in the voter file. And I'm not even kidding you with this one. They say, oh, the legislature's intent, if the intent of the legislature was for the election officials to compare the date, address, name, signature from what's on the declaration to that with what's on the file, they would have said therein instead of compare that information thereon. You can't make this up. It's like who takes that seriously? Who, like, even if you think that this challenging of the election and the election integrity is completely undemocratic, I don't know how you can be like, oh, because they use the word thereon instead of therein, the person doesn't have to fill out the outer ballot. I don't know. Okay. And so it's like, okay, you want to get ambiguous with language? Lego, let's do it. Because I've had quite a few experiences where I have experience in ambiguity of language, okay? So let's do this. If I could put that on my resume, I would. So they want to say, oh, so they say all of this ambiguity of language is the outer ballot doesn't need to be filled out. And the outer ballot is basically the proof of identification of that voter with the proof of identification at the office. And so what I'm going to argue is that when in the law it says proof of identification, I'm going to argue that a signature is a proof of your identification. Because anytime you go anywhere, they say, oh, you need your driver's license as a proof of your identification. What's on your driver's license? Your signature. What's on all these chain of custody documents for these drop boxes? Their signature. And they say, oh, here's a phone number and email, and if there's anything wrong, or if a county election official has to write which drop box they picked up, and if there's problems with that chain of custody, you refer to that signature, right? So yeah, I'm basically saying that proof of identification is signature is a part of that identification. Yeah, and then it says compare that information with the information on the voter file. Again, the information on the voter file and your voter registration card, you have your signature on there. So when it says compare the, like, to me, I said the information that includes your signature, in my opinion. So another argument, and I guess this goes with ambiguity of language, and this one's for the date, is they say in the law it says to put the date, and they say, well, you can either see that as a mandatory obligation, or you can see that as kind of more of a directory instruction. And it's like, oh, we're getting all Pirates of the Caribbean on this. Oh, they're not rules, it's just guidelines. And so it's like, really, you're arguing that what they state in the law is not a mandatory obligation. Now your argument is that what they state in the law is just mere directory instruction. I mean, I can understand how you think that way if this is like your thinking. But I guess if you don't think that way, it seems really like problematic to say the least. Okay. So this is a quote from the law or the opinion, I think, of why there shouldn't be a signature analysis and ballot set aside for that. And it says, oh yeah, this is the opinion. So the voter could have easily concluded ... something, and then to add further confusion, the declaration itself can be read to refer to the label, I hereby declare that I am qualified to vote from this below stated address, can be read to mean the address as already stated on the label. So he's basically saying, oh, maybe the voter didn't put their signature on the outer ballot because they were confused. They thought that as soon as they signed that at their home, that's where they could vote. And it's like, so then did they think that they had to go to the office on election day to sign it? I don't know. And then I guess to add insult to injury, to pour salt on the wound, he says that he's like, oh, voters might not sign it because they might get confused that people can vote at their house. And it's like, oh, does that mean that the voter who thinks that they can vote at their house means other voters are going to come vote at their house? I don't know. Yeah, and then to add insult to so before he says that though, before he mentions that scenario, Ziccarelli, I'm sorry if I mispronounced your name. She's been fighting this, and she says she thinks there should be a signature analysis and requirement, and you can set ballots aside based off that. One of her arguments was, oh, and this was about the date. It says that she argues that, oh, the date is important. It should be a mandatory obligation. It is a part of the safeguards that are set in place. For instance, the time that the voter applies for the mail-in vote, they could have lived in the county, but the time on election day, they could have moved and not be eligible to vote in the county. And that's why you need the date. It's not just an instruction. And it's also, she doesn't think it's an unhypothetical scenario. And even the law says here that you can challenge the absentee elector upon the grounds that the elector is not a qualified elector, or that the absentee elector was within the municipality of his residence on the day of the primary or election during the period the polls were open, except if you're like in the military and stuff. So it even says it in the Pennsylvania law, the scenario that, oh, you might have applied for it, but you moved and you're not qualified to vote in this county at the time of election day. So it's not an unlikely hypothetical scenario in those two aspects. So that was another reason why you need the date. It's not that the date on the declaration is a mandatory obligation and not just some superfluous directory instruction. Okay, another argument for the signature analysis, and this is a quote from the lawsuit. It says, oh, the Secretary of State argued that, oh, there's no standards or guidelines within the election code governing how an election official should perform such a comparison. I guess she means comparison of signatures specifically. Well, I'm gonna discuss the 3 guidelines that the Secretary of State sent out, and those weren't guidelines within the election code. So that part's confusing. Okay, and